Hello and welcome back to Fully Booked, the Hidden Gems author podcast in which Craig Touch, myself, Roland Hume, chat some interesting figures and leading lights of this crazy industry we're in of writing and self-publishing. And today we have a very special guest. We are delighted to welcome Sarah Marie Page, who is literally the double hitter, the complete package. Not only is she an author under the name Sarah Marie Page, but she is also a lawyer who does estate planning, and that's what we are here to talk about today. So Sarah, thank you so much for joining us. I love your Christmas tree in the background. I guess you're not getting any snow in Arizona right now.
No snow in Arizona, but it's raining today, and so my thought is that we would have had a white Christmas if it wasn't 60 degrees outside.
Absolutely. Well, thank you so much for joining us. We are really, really delighted to have you here. But of course, we wouldn't be here without the man himself, Craig Touch, the owner and founder of Hidden Gems and an author himself. How are you doing today, Craig?
Doing well. Thank you, Roland, and welcome, Sarah. Yeah, over here, it's I'm in Canada, and I don't even think we're going to have a white Christmas. So global warming, what are you going to do?
Yeah.
So listen, today we are happy to have you on because this is something that an author had sent me a message about this a while back, asking about this question, and then I had sent it on to the author newsletter that I send out on Fridays. And there was a lot of interest about it, and it's the idea of estate planning, and the fact that when you pass on, all of your writing it doesn't disappear with you, right? So it's all still there, and somebody has to not only take care of it or manage it, but they need to get the money for it. You don't want it just sticking with Amazon or Barnes or anywhere where you have it for sale, right? So you want to make sure that all that stuff is sort of taken care of, and just saying, they'll figure it out when I die is not great. It's not a great solution.
Definitely not great.
So yeah, we want to go over this with you. You're an attorney that deals with this sort of thing all the time, and we want to sort of get a list of what kind of things that people have to think about. Of course, they should consult a lawyer at some point as well. Things are going to vary state by state, country by country, but there are certain things that everyone will need to think about. Certain steps like keep your passwords somewhere that people will have them, or make sure that this is done and that's done. I mean, you probably know better than I do what all the steps are. So let's talk a bit about this and go from there.
Yeah, so I want to start out making sure that we are on the same page. And to preface, you did a great job prefacing. I'm just going to preface again. I am barred in the state of Arizona. Any examples that I give are going to be under Arizona law. Your state might be different, and each state is going to have different rules. So it is important to consult with attorney. But let's go ahead, and I want to lay some basic framework because I know some people listening to this are probably very familiar with estate planning and have their estate planning done. And some are like, estate what? So laying some basic groundwork, there are usually 5 different ways that you can pass title to property when someone dies. And this is really title to anything. So it's titles to a house, title to bank accounts, title to vehicles, also title to literary rights. So the first asset, or the first way to transfer titles to things when someone dies, is by owning something jointly with rights of survivorship. If you own something jointly, that means the 2 of you own it together, and when one of you dies, it passes to the survivor. The second tool that we have are beneficiary or pay on death designations. A beneficiary or pay on death designation is like a tag that you put on an asset and you say, this is where I want the specific asset to go when I die. So a common place that you see that is beneficiary designations on like life insurance and retirement policies. I should back up and say common place that you see joint ownership is between husband and wife. So we have joint ownership, beneficiary designations. We also have trusts. A trust is kind of like a contract that you can update as many times as you want when you're alive. And when you're not alive, you're not around to update it anymore, and the trust becomes irrevocable and gets administered according to the terms of the trust. And that's kind of an oversimplification of trust. There are about a jillion different types of trusts with like crazy names like Q-tip trusts and Just like super crazy names, administrative trusts. But generally, the basic trust that you do with estate planning is called a revocable trust. You can change it whenever you want when you're alive. When you're not alive, it becomes irrevocable. The trust will hold title to property, and the property that's held by the trust gets administered according to the terms of the trust. The thing that makes each of those strategies special, joint, beneficiary, and trust, is that we did something fancy to the title. So with joint, we got 2 people on the title and we said give it to the survivor. With beneficiary, we titled that property in the name of the trust. With beneficiary, we put that tag on that asset, and with the trust, we titled that property in the name of the trust. Can you guys tell that I have given this feel? My brain just starts like forward. I take a very educational based approach with estate planning. So I really try and make sure that all of my clients have this groundwork before we begin diving into the specific tools that we have. So the 4th tool that we have is something called probate. Now, if you know anything about estate planning, you probably have heard like, oh, you want to avoid probate. And people come in and they're like, I don't even know what probate is, but I want to avoid it. I know it's bad. What probate is, in simplified terms, only you can sign your name. So I cannot walk into a bank and sign Craig's name for him. That would be fraud. And that principle carries on after you pass away. So if you own assets in your own name, you didn't use any of the 3 tools that we just talked about, those assets are stuck in your name. What do? Your people that you left behind go to court and they say, hey, judge, Craig passed away. Craig cannot sign his name anymore, lest we have like a Ouija board ceremony with where he comes back. And anyways, but Craig can't sign his name anymore. Please appoint me to sign on his behalf. And the court will do that. And they impose a lot of, in Arizona at least, and in many states, they impose a lot of restrictions on that. So, they're like, okay, you can sign Craig's name, but we want to make sure that you don't run away with the money. And we want to make sure that you're doing your job and keeping everybody notified. So we're going to babysit you. That's probate. Okay. The final tool that we have are small estate affidavits. A small estate affidavit says that the value of the assets that would be subject to transfer, it's so little that it doesn't make sense to open probate. So if you have a bank account and in that bank account, there's $10. That bank account is in Craig's name, so nobody else can go get that money because it's in Craig's name. But does it make sense to go bug the court to be able to get that money out? No, it does not. So the people who are entitled to that can go in and say, hey, bank, this amount is so small. I swear I'm entitled to it. Let me have that. The amount that you can pass is going to vary for each state. So for example, Arizona has a very high small estate affidavit amount. You can pass up to $75,000 of cash under that small estate affidavit. In Arkansas, and I know this because I was looking it up for my sister-in-law who lives in Arkansas, just kind of curious. We were chatting about some general estate planning. I was like, I wonder what it is in Arkansas. It's like $2,000. It's very low. So it really varies across the board what you can pass without that probate. So when you are estate planning for someone with literary rights specifically and who's an artist, so this also applies to, painters and musicians and people whose work lives on past them. I've done estate planning and dealt with music rights actually quite often. They're usually pretty small, the royalties that they kicked off. But the first thing that you want to look at though is how are those titled? Like currently, like you sit down, like, do you have an LLC? Are you running your writing business? Because if you're writing and you're putting work out there and you're getting paid for that work, you're a business. Whether or not you have formally set yourself up as a business, you are still operating as a business. So how is that business held? Do you have an LLC? If not, you might be what's called a sole proprietorship. A sole proprietorship is basically just, anybody who anybody can say like, look, this is Sarah's cookie shop, and I don't have to go incorporate that with the corporation commission for the state. So how are those assets currently being titled and currently being managed? It's the first step. Okay. The second thing that we got to think about is, what exactly do we want to do with those when we die? Like what is the goal and what is your vision behind this? A couple of ideas. So the first thing is, you could give it to one person and say, Ronald or Roland, you get my writing, my rights to my writing, and you can do with it whatever you want, and you don't have to share. You can like, they just become yours. Okay.
I'm loving this deal. I'm loving this deal.
You love this deal. Perfect. I don't know how much you'll actually ultimately get from royalties, but you can have them, and then you can do what you want. And so you can give it to one person. You can also, everybody has, like, if you think of like literary estates, the big literary estates, I always think of like, actually the one that comes to my mind immediately is Elvis Presley. And like the Elvis Presley estate, it's like currently being managed, and they can enter into contracts and like, get the music used in movies and stuff like that. So I know that's a music one, not necessarily a literary one, but do you want to set up something where there's one person in charge, and that one person is going to manage it on behalf of the rest of the family? That's another option. If you don't specify in your estate planning the person that you put in charge to administer your estate, or the person that is put in charge by the court to administer your estate, will make that determination and work with the heirs on that. And so typically when I've dealt with this, and I've dealt with this on the music rights standpoint specifically, so the decedent had some songs that were getting royalties. They were like $5 a year. Like, they were like very, very minimal royalties. And she did not specify what she wanted to do with them under her estate plan. Her brother was actually like interested in having these. We had to go get them valued. So figure out like, okay, they produce about $5 of royalties a year. What is the value of that? You can find someone to value anything. And so you go get them valued, and then he takes that as a part of his share of the estate. So everybody gets a little bit more cash, and he's offset for the music rights and the value of that. But, I think, and this is just my personal opinion, unless you're like a big name author and or like planning on putting out and doing like big things with your stuff after you die, it's probably easiest to just give it to one person and just say, you can have it and manage it and do whatever you want, instead of trying to set up something where, there's one person in charge and they're managing it for the family, and they're cutting checks and royalty checks to the family. The reason behind that is because it's a business. And businesses have cost to upkeep. If you're only getting like $5 of royalties a year, or even $100 of royalties a year, or even $1,000 of royalties a year, you have tax filings that you have to do, and you have, you have accountings that you have to do to keep everybody updated and in the know. As families grow and expand, you have more people to keep track of, and more people that you are, beholden to for information. And so, if for most people, what I would recommend is either give it to someone specifically, or, you just don't specify and let the family decide and see if anybody wants it. So I would also recommend, when you're considering like, okay, I'm going to be like the Elvis estate, and it's going to like be big and enter into like all these contracts and be managed on behalf of the family. You got to think about like how long this can go on for. There are rules on that. So for example, and each state is going to be different. In some states, there's something called the rule against perpetuities. And the rule against perpetuities is so complicated that there's actually law that says if attorneys get it wrong, that's not malpractice because it's so complicated. But basically, it's all lives and being at the time that the trust was created, plus, or the time that the will was created, either one, plus 21 years. You can get in some really like mind bendy. It sounds simple when you say it, but when you start running through like hypotheticals, it gets mind bendy. Some states like Arizona, you have 500 years. Also, you might want to consider like when the copyright runs out as well too. So like, do you want it to extend past the copyright, or do you want like, does it terminate when the copyright runs out? Is there a way that you can, and I don't do copyright law, so I don't know the answer to this one, but is there a way that you can extend the copyright? Disney's attorneys seem to be doing a very good job at extending the Mickey Mouse.
Yeah, that's what I was going to say. Disney's figured it out.
So there have got to be ways to do that. But yeah, so that's kind of the practical like nuts and bolts. When you're considering like who to nominate and who to put in charge, unless if you're giving it to someone outright as a gift, here you go, you can do whatever you want with it and you don't have to share with your family members. You know, they can be as good with business or money or as bad with business or money as you want. They'll just manage it. But other things to consider, like if you're setting up something that is going to last for many, like, you know, you're going to be like the Elvis estate where you have someone in charge and making distributions for the Michael Jackson estate. Things to consider for that are you want someone who's like business savvy is what I would recommend. And this is like general like estate planning too. Like if you're putting someone in as you're thinking about who to nominate to be in charge of your estate, you want someone who kind of like understands like business and money and is kind of good at that. They don't have to know everything. Like I have a lot of clients who come in and they're like, well, they don't know like taxes and they don't know the law side of stuff. And from the literary planning perspective, they don't know like copyright law. And I'm like, they don't have to know everything. They just have to be like savvy enough that they know to get help when they need help. So consider putting someone in who's like business savvy, but also knows where their limits are and knows when they get help. I would also encourage you to consider like the relationship with the other family members. Like, does everybody hate Joey? If so, probably you don't want to go ahead and list Joey as, you know, the person that's going to be in charge. The thing that, no, Joey. You know, the thing that surprises, I think, a lot of people, so when you think of like these big like literary estates that continue on for many years, they're not actually like technically estates. So an estate is something that you open up through probate. And that's that process of petitioning the judge to sign on behalf of someone. Now, each state is going to be a little bit different, but from my research, it seems like those are mostly actually trusts. The reason is that judges don't like to leave estates open for many, many, many years. In Arizona, you get like 2 years and then the court will start sending you nasty grams being like, you got to relinquish the power to sign on behalf of Craig. You got to like wrap this up, get this done. And so like the Elvis Presley estate, that one actually is a trust. And so oftentimes these big literary estates, they're held in trusts. What questions? Do you guys have any questions? I just spewed a ton of information.
Yeah, well, listen, I mean, I think that's really important information, but I think a lot of it is more specific to people that are, you know, have these big publishing empires or a lot of, you know, income coming in, whereas there's a lot of authors that, you know, that listen to this that are self-publishers that don't have a huge amount, but it's still significant enough that, you know, you don't want it to just disappear or get lost and forgotten. You know, you might have 10, 20 books, maybe less, that are generating some sort of income. And then, but your spouse or whoever is left behind might have no understanding at all of what you have done, right? And so you pass away and then they just, you know, they don't even know about that stuff. So I guess, you know, one of the things we want to sort of think about and talk about is maybe something that you can do to leave behind to make that easier to people. And one of the things obviously is like, you and I had discussed this sort of offline, is password list, some sort of, a list of all your accounts that have to do with publishing and your books, let's say, and all the passwords for that. I know for me, I have an Excel spreadsheet that is itself password protected, and it's on like a Dropbox, and so that way I can access it from anywhere, because every website in the world wants you to have a secure different password, and I'm pretty good with that, but I can't remember them all. So if I'm out and about and I need a password, I can go on to that, check, log into that. I only have to remember the one password to that Excel thing, and then that has all my passwords in it. And so for me, it's like I've left behind in a spot that my significant other knows about, the password to that, the location and the password to that is on a piece of paper somewhere that they can find, and so that they can access, and then they'll have access to all those accounts, right? But that's just one way of doing it. There's also, I know there's a Google service that is free service that basically it's like the inactive account manager, I think it's called. And if you don't log into your Google account for, I think, something like 3 months, or maybe you can set it, it will automatically send an email that you've pre-written to your designated person that you want it to go to. And that could have a bunch of instructions as well. And so, just sort of ideas of that, and what do people really need to know? Like, I just have that big password dump, and it's not just publishing, it's every account, everything I have. But I probably need something where it's like, okay, here's all my books are on this site and this site. You would have to go in here, and the money is going to come to here, and it's being sent to this account. We sort of need sort of almost like a roadmap of what you need to sort of tell that person ahead of time, or write it down to make sure they get it.
Communication is key, and I think you really hit on that with the passwords. It's super important to make sure that your family knows, one, what your wishes are with your work after you pass away. Like what do you want to happen with it? What, like, how do you want it to like continue to, and two, like how it's set up, and like passwords definitely matter and are super important to make sure that people know, where, like, if you died tomorrow, like, would people know how to access your stuff and where your stuff is? Like, I don't think you have to like tell them like, oh, here's the passwords for everything, but just having a list with your important documents that people can find, or telling them like, hey, I have a password list here if you trust them. I recommend, printing out a list of websites and holdings. You would be shocked at how many times people come and they're like, I don't know what my parents owned. Or the weirdest one for me is, I don't know what my husband owned. I'm like, how do you not know what your husband okay, then you end up looking for assets, and it ends up being expensive, and you possibly losing money at the table. So a list of anywhere, like any bank accounts that you have associated with your publishing is helpful as well. I tell my estate planning clients to just print out a statement from that account and to put it in with your important documents. So if you have like an estate planning folder or an estate planning binder, you can slip it in there. Most people have some sort of place where they put their birth certificates and marriage certificates and stuff like that. So if you have a spot where you keep important documents, slip it in there, and then they can see what that account is and how it is titled. And then making sure, like, and this goes back to the beginning and what I was saying, like, how do you have your author business titled, and how are you managing that? Because if it's like an LLC, you want to make sure that you have steps in place and provisions in place where you can put, most LLCs are either member managed or manager managed. You want someone to be able to get someone in the driver's seat to be able to make decisions on behalf of that LLC. If you're just running your author business as a sole proprietor, can you assign those rights to a trust where the successor trustee can come step in and can, manage things? How does someone get the authority to manage that business? And that's what you got to look at and what you got to think about too. Or do you need the court to go ahead and give someone the authority to manage that business?
Yeah, and I think one of the things to keep in mind and is, like you sort of said before, the idea that people don't even know what the other person owns even when they're married, and I get that. I mean, sometimes a lot of times there is one person in a relationship that sort of handles all that, right? Because it's just what you do. You split up tasks, so often that's one of the tasks. Somebody does the money stuff and somebody does this. So there's very likely, like you said, lists of assets that the other person doesn't necessarily know about. They know they have RSPs, they know, or savings plans or retirement funds, but they don't know exactly where they are and what. So yes, that having a list of that, printing out the statements, like you said, is really good. But I think as well with your writing, a lot of the times, somebody in a relationship is the author. The other person, they have no idea about that world at all. And so I wonder, just leaving them a list of your assets and saying, hey, I've got books here, they might get them and be like, I don't know what that means, what to do with that, information, right? It's almost like you almost need a step-by-step thing.
Yeah, I mean, you can definitely prepare a letter, this is how you access my KDP, Author Central account, and this is how you log into the bank accounts.
And this is what you would need the KDP account for, right?
Yeah, this is why you need it. This is if you do this, Amazon's going to send you a nasty gram and don't, you can. Also, people figure it out. I have seen with music rights, especially, people come in and they're like, and maybe, the music rights specifically, the times that I've dealt with those, they were getting royalties specifically from a record label. And so it was a matter of getting the person who was the payee of those royalties switched and just getting the paperwork in to get that switched. But people are savvy and can figure things out. But yeah, if you wanted to prepare a letter of instructions, that would be helpful. And that's definitely something to consider doing. So list of passwords. So far we have list of assets, accounts, where you're doing business, what sites are generating revenue for you. Making sure that you have
go ahead.
Yeah, I was going to say making sure that you have paperwork in place so that, and this is something an attorney could help you with, paperwork in place so that somebody can access and manage those accounts and those sites without having to get permission from the court. And what that looks like is really going to depend on how you have things structured.
Right. And then I'm thinking too with social media. So a lot of times an author would have a social media following. So, maybe you want instructions on how to communicate, your death to your social media following, or what you want them to do. Close down those accounts, send out a message, keep them going, maybe you already have a virtual assistant who manages all those. Maybe you don't want anyone to know that you died because you read under a pen name, and they'll never know, right? So that kind of thing maybe as well.
Yeah, and I will say, if it's not in writing, it didn't happen. That's kind of an estate planning rule. You would be shocked at how many times people come in and they're like, Grandma wanted me to have XYZ. I'm like, if it's not in writing, it didn't happen. Quick war story, not necessarily about literary rights specifically, but just about somebody's wishes who did not get respected. So if you have specific wishes, write them down. But my husband's my husband's grandpa, so my grandpa-in-law. Now picture he is a surfer dude from the 1950s, like beach bum, 1950s beach bum, okay? And he always said, I want to be cremated and my ashes spread on the beach. That was his wish. He didn't write it down. And the aunt that they put in charge had some deeply held religious beliefs about burial. And her dad did not necessarily share those beliefs. She had those beliefs. And so she said, you're not cremating grandpa, and had him buried in a rose gold discount budget Costco casket. So surfer dude grandpa buried in the pink casket. I think he might have actually been rose gold. Yes, from Costco. It was on sale.
I didn't even know you could get
caskets.
Yeah, that's what I was gonna say. I didn't know you could get caskets at Costco. Wow.
You can't get caskets at Costco. But yeah, it's the same thing with like literary. Like if you have someone that you want to manage things or you have specific wishes, like, hey, will you please, after I die, send this picture and post it on social media and send it to my email newsletter contact list. That's another password to write down if you have an email newsletter, and like where that's held, like is that on MailChimp or like ConvertKit or MailerLite or like the pretty common ones now, Substack. But you know, like I want you to send out this joke to all of my fans. They will think it's really funny because it's been a running joke in all of my books. Like communicate with that. There is law in Arizona, and I'm sure other states have something similar, where if you write down your wishes for like funeral and like those have to be followed.
Right. So what I was going to ask was how formal are we talking? Because if somebody, let's say, they write an email to their spouse and say, hey, by the way, if I ever die, this is what I want to happen. Let's say, in your case that you gave there, let's say he had written that email to somebody at some point and said, I want my ashes spread around the beach. I want to be cremated, etc. If then that aunt was put in charge and said, well, I'm going to bury him, but then this other person came up and said, hey, I got this email telling what he wanted, how would that have to be respected? Or does it have to be in a will or something like that?
Yeah, so I would say I usually do put like last like requests for the body into the will. Like that's where I usually put those. Talk with an attorney about your state specifically, because this is an area where state law like really change, and you don't want to do something that will accidentally mess with your other estate planning. For example, Arizona is one of those weird states that you can change a beneficiary designation with a will, and you can make a will if you just like write out like, this is my last will and testament. I want to give blank to so and so, and so you can, if you get wild with it, kind of like mess up an existing structure. But this is a place where meet with an attorney, say, do you have in my state, like, do I have laws specific about like if I write down, and then like how should I write that down? Is a letter just okay? In Arizona, I think I would say, write up a letter and sign it. Like, don't just do it as an email. Write up a letter, sign it, put it with your important documents. And hopefully you're putting someone in charge too that's going to respect and honor those wishes.
Well, that's what I mean. Like, sure, it might not be strictly legal, but I just wonder whether or not they take those things into account. If somebody had come out and said, hey, I did get this email where he just told me that. I know it's not written down anywhere, but it doesn't conflict with anything that is written down. It's just like he never said, he didn't have a will, or he never specified how he wanted his body handled. But look, he sent me this email 3 years ago saying that. And I mean, I'm sure that the family who he had told that to probably did come and say, no, that's not what he wanted. But if they had something written, would that have given it more weight, I wonder, even if it was just an email or I don't know.
Yeah, I think if they had something written, that would have given it more weight. Now, if everybody's in agreement, like grandpa's like, please cremate me and spread my ashes on the beach, and everybody's like, and he puts that in writing and makes it so beautiful and like puts it on the front page of all of his estate planning documents and is like, cremation, beach, cremation. And then everybody comes and is like, no, rose gold casket in the ground. Like who's gonna, like practically speaking, and this is like the reality, like who's going to contest that? But if he did have something in writing, I think that would have helped. Now, there's also the practical reality of, okay, are you going to like litigate this? Are you going to bring it before a judge and have the judge, you know? But I do think that probably would have helped in that case.
Right. Yeah. And I think, it really helps people. You were saying earlier, people figure it out and stuff like that, but it really helps, especially at that time. They're already dealing with the loss of this person. To have to figure stuff out and to have to guess at what they wanted, it really it helps to just leave them some instructions so that for their peace of mind, sure, maybe they won't listen to it. But I think in most cases, unless they really didn't like the person or whatever, they're probably going to be like, okay, well, this is what he wanted, so let's do that, right? Even if it's not written in a legal sort of document, they'll be like, look, I had this email from last year and he said what he wanted, and so let's just do that. It would just be easier, I think, for most people.
Yeah. And I will say most families that I see, they love the person that passed away and they want to do what is right for them. I have people come in and they're like, my mom nominated me to be trustee, and like I'm in the middle of the messiest divorce and losing my house, and like, but I'm gonna do it. I'm gonna be trustee. And I'm like, you don't have to do it. You can have your sister do it. She's nominated as the second one if you can't do it. And she's like, no, that was mom's wish, was that I did it. And so like oftentimes people do take those last wishes very, very, very seriously, and they want to honor those because they see it as a way of honoring you. And I will say many families that I see like get along great and everything, everybody agrees. And it's just like, doing all the formalities to make sure that the assets are transferred to the right people, the royalties, like, are they going into the account for the LLC? Okay, well, then we want to update and make sure that we have access, like who's getting that, it's just making sure that everything is like flowing in the right direction, not necessarily battling. But I have seen some really messy cases where people fight over assets because death brings out a good side in people, and it can bring people together. It can also tear people apart. And I think this is one of those areas where an ounce of prevention can create a pound of pain and a world of hurt for your people,
Yeah. And I think, people that, I don't know, it's probably a generalization, but I think that the more money you have, the more likely people are going to be to fight over it. They're likely not going to be fighting over the small amounts that are coming in from a lot of the self-publishers that would be watching this. I don't know. I'm sure that's a generalization.
Well, okay. So this is what I have come to learn through estate planning is that money often amplifies more of what you actually are. And so if you are a kind-hearted and giving person, money amplifies that. Like using Taylor Swift for an example, she gives away like millions of dollars every time she like stops somewhere. She's like giving away to charity, and she like bonused out all of her truck drivers for her tour. Like money will oftentimes make you more of what you actually are. On the flip side, I have seen people fight over stupid stuff and like spend thousands of dollars fighting over stupid stuff. And sometimes that's silly stuff is like the stuff that's sentimental and has a sentimental value. For example, one of the first cases I did was terms on a charm bracelet and fish cups. Two sisters suing each other over terms on the charm bracelet and fish cups. And I was writing up the settlement agreement, like the 20th anniversary charm goes to Sally and the 50th anniversary charm goes to May, like actual lawsuit filed in court. I've had clients come in again with like music rights, and they're like, I know it's probably going to cost me more money to acquire these rights and to to get them transferred to me and do all the paperwork and all the time, and like then what the little bit of royalties that they're kicking off, but they meant something to my dad, and this was his art, and this was important to him. And because it's important to him, it's important to me that I safeguard it and try and make something of it. And she's like, I may never be able to make something of it, but I want to keep trying for him.
Yeah, sentimental things for sure is also something I think that people would fight over more. But it's also, and then that makes sense. Like, I mean, people spend money on frivolous things and, hobbies or whatever. So saying, oh, it's going to cost me more to honor my parents' wishes and safeguard something that was important to them is no different than blowing it on, a hobby, So, I get it. But hey, there's a lot that every situation is going to be so different. And I think that the important thing is really just understanding like what the basics are that you need to do is, keeping this list and these are the factors you have to consider. And, all that stuff is really, and not leaving such a burden on people, even if they can't figure it out, at least give them some direction about where to look, where to start looking, and what your wishes were, so that they don't have to necessarily figure it out, and they don't have to guess at how you would have handled things.
I would say too, one final note is to make sure that you update things. So like, don't just create a list and then be like, check, done, never have to think about that again. Because if you create something and it was a snapshot of what everything was like, 5 years ago, publishing moves really fast. And, there are new things popping up all the time. Now Spotify is doing audiobooks. I mean, that they were not doing audiobooks, I think, last year. It's pretty new. And so, just keep your list accurate, and maybe just like calendar a time to review that. I've heard of authors who are like, yeah, I calendar a time and every month I submit for a new BookBub featured deal, and I never get them, but I submit it every month and it's on my calendar to do. Like, maybe just calendar that like every 6 months, pull out that password list and be like, okay, did I get locked out of my account and have to change my password on something? No. Okay. Did I like open up a new account? Did I like find another stream of revenue that I need to now account for? Like, for example, if you branch out and you're now doing like print on demand, or like, like, is there something else I need to like account for and put in this, just so that they know what's out there and how things are structured?
Yeah, I mean, I even forget about some of the things that I've done. And, once in a while, I did this experiment a while back where I put a few of my books up on Radish, and I forget about that because I did it one and done, but then every once in a while I remember, or I see something about Radish, oh yeah, and I go in, I look, and I'm like, oh, I earned some money. I totally forget about it. So it's easy for me to forget my own stuff. Forget about it. Somebody who doesn't understand all that stuff already. So yeah, keeping that list is probably important, even just for yourself.
I think that might be like the most important. There's been a lot of important stuff that you said over the course of this podcast, but that might be the most important thing. In fact, I think I might go make a list of my passwords after.
Yeah.
So my wife was very interested in this particular episode, and also she got me life insurance for Christmas. So
excellent Christmas present. I will also say, like, pro tip to anybody who has an Apple, like who uses Apple and has like iPhones, Macs, like, make sure you write down like the Apple password too, because so probate costs, like, I tell people it starts about $5,000 to open probate. That's really expensive. And I've opened up probate solely to get an Apple password. So that password to get was $5,000. And that could have been solved just by writing it down. And for a long time I was like, why did this guy come to me and want me to open up probate for the password? Like, he comes to me and he's like, I tried logging in, I locked the account, I reached out to Apple. Apple said they won't release the password without a court order. Can you help me get the court order? I'm like, yeah, that's probate, what you're asking for. He didn't say why. Okay. I'm like, okay, well, yeah, I can help you do that. As I thought about it some more, it was like all of her all of her pictures, the pictures of his wife that she had taken, all behind that password.
Wow.
So yeah, I would pay $5,000 for pictures of my husband, you know?
Mhm. Yeah.
But yeah, so make that list, keep that list updated. Don't just let it sit in a hole, in like a dark and dusty corner of your office. Like leave that space for the trunked manuscripts. And probably put it like with your important documents is what I would recommend.
Yeah, for sure.
That makes a lot of sense. Well, unfortunately, we reached the top of the hour, so we're going to have to wrap this up. But I think this has been a very, very important episode for us writers. I mean, you never know. So you might write the next, I don't know, the next Hunger Games series, but it doesn't become a bestseller until the day after you get run over by a bus. And so, what's your family going to do?
Yes,
Right.
Exactly.
So steer clear of buses is one piece of advice. But Sarah, people will have a lot, I think, to say. A lot of people will be very interested in finding out more. You have your books under Sarah Marie Page. You practice law under Sarah Clifford. Where can people find you in both realms?
Yeah, so Page is my maiden name, and I write under my maiden name. Marie is actually my middle name. So Sarah Marie Clifford, Sarah Marie Page. I write under my maiden name. So you can find me at my website, sarahpagestories.com. I write a lot of like romantasy. I know that's like really hot right now, but that is my genre. And so I have a short story that anybody who is interested can download and read about a princess to be and a sexy demon prince. If you are interested in finding me on the law side, my legal name is Sarah Clifford, and that's Clifford like the big red dog, not Clifford with it. Anyways, it gets mispronounced all the time, but Clifford like the big red dog. And I work at Davis Miles McGuire Gardner. We're one of the largest law firms in the state of Arizona, based out of Tempe. So if you are in Arizona and looking to get estate planning done, I'm more than happy to help.
Well, that is fantastic. We will obviously put links down there. Do you represent sexy demon priests as a lawyer?
No, I haven't presented one yet. But if anybody knows of one, I'm sending my way.
Excellent. Well, thank you so much, Sarah, for joining us. We really, really appreciated it. If you have liked anything that Sarah had to say, if you have any comments or anything, don't be a stranger. Scroll down and leave a comment in the comment section down below. While you're there, hit that subscribe button, hit that like button. There's a bell notification, so you'll find out every time we have a new episode of Fully Booked. And we'll be back next week with a brand new episode. So until then, cheerio.